So hi everyone, thank you for joining us today. Thank you, Francisco, for speaking again. I know you've spoken at a number of our events in the past, and it's always great to have you. Definitely a great source of information. So Francisco Remolino is a licensed insolvency trustee with over 15 years of experience finding solutions for clients in financial crisis. Along with his proven track record of success in helping individuals and businesses handle proposals and bankruptcies, he brings a unique perspective and humanistic attitude to his approach. Numbers won't tell the whole story. Francisco's first focus is on you. In addition to running the practice, he is also a sought-after financial management authority who speaks for organizations and conducts workshops on topics such as money and risk management, financial forecasts, and debt assessments to both editors and creditors. Thanks again for speaking, Francisco, and good luck with your presentation.
Okay. Let me just stop this here for a second. Good afternoon, everyone, and thank you so much for being here today. I hope you are all enjoying the different topics the conference has arranged for this afternoon. And for the next 30 minutes, we are in for a treat. And I think we all have so much to learn. There's a lot of information around the current solutions for businesses that are struggling with the results from the pandemic. And so as accountants, as people that is in charge of the business decisions, business owners, and in fact, so I think what we're going to discuss today is how insolvency, but more particularly how a proposal to the creditors can be the lifeline a business or your business needs right now. So I'm going to share my screen that we can go over the topics that we have prepared. Perfect. And so again, the topic for today will be how a proposal to creditors can be the lifeline your business needs right now. I will go over a lot of the information for the next 30 minutes, but please feel free to share any questions you may have. If the questions we can answer throughout the presentation would be great. Otherwise, I can also have an allocate some time at the end of the presentation. Perfect. So what we're discussing today, we're going to discuss 3 different topics, and one of them, they're all in relation to a business and how a business proposal can be a good option for a particular financial struggle. The number 1 topic we're going to discuss are the initial considerations. So what is important to discuss, what has to be taken into account when looking into a business that is struggling. Number 2, a business proposal, how a business proposal to creditors works, more of the technicalities of it. And number 3, we'll be discussing from the perspective of the creditors what remedies are available when somebody owes money to you, or when you become a creditor in an insolvency process, or what remedies do you have to enforce the business relationship we have with a particular client. This is just a standard disclaimer to ensure you all understand this is not legal advice. What we're going to discuss today is more of the general terms of how an insolvency can work for a particular business. But what I encourage you to do, if you have any questions in particular about a particular situation, you can contact me directly and we can discuss that through email or chat. Okay, when it comes to the discussion around a business, a particular business, what are the initial considerations we need to have, or we need to take into account? Number 1 is the type of business. And I'm going to refer really today about small businesses. And one of the options that we have for a small business is to have a sole proprietorship, which some of you may know is an extension of the personal affairs. So if somebody is practicing as a sole proprietor, the business is also the individual. That is important to understand and to know once you are looking into the debts of the business and more so into any kind of insolvency. The second type of business that I want to discuss is a corporation. Corporations are a separate entity from who you are as an individual, and therefore there are some benefits of running a corporation. There are also some obligations of the corporation in terms of its own institution. So I think it's important to understand the distinction between those two when deciding as to whether an insolvency or a business that is struggling should really look into insolvency. In terms of the type of creditors, we'll be looking at, I think one of the biggest considerations is what kind of creditors do we have? What kind of creditors the business has? Are there employees? How employees' claims are processed? Very important, kind of revenue agency, what kind of debts to the CRA are outstanding? Very important to consider the source deductions. Source deductions is considered a super priority, and therefore they will have to be paid within 6 months of any kind of insolvency, and is normally paid outside of the sale of the assets. And also a consideration around HST. HST is considered a debt that will also transfer, even though it's an unsecured debt, but it will be a debt that also transferred to the director's liabilities. As a director's liabilities, and we're going to discuss this a little further down. And we also have to consider in terms of the type of creditors, if there are any personal, any secured creditors, and what are the terms of those securities. And now another consideration are the personal guarantees, and personal guarantees are very important simply because that will determine whether or not or what kind of negotiation you can have with the creditors. If there is an unsecured creditor with a personal guarantee, then maybe it's worthwhile to bring that conversation at the personal level, more so from the business. Again, we're looking at what personal guarantees have been given, and for the most part, typically, a new business will normally provide personal guarantees for any kind of business loans or business lines of credit or business credit cards, simply because the business doesn't have any background, any historicals, or any history with the banks, and therefore a personal guarantee is required. In these particular cases, again, when we're looking at the individual being responsible for the business debts, then the options may vary from that perspective. We also have to consider the director's liabilities, and these arise from the corporate debts. As I mentioned, HST being one of them. And so if the business is unable to pay his HST through any kind of insolvency, then it is transferred to the directors as a director's liability. So this is a consideration that we also need to look into before deciding on any kind of insolvency. And the last part, which I think is very important, but also sometimes we kind of really don't pay enough attention to it, is the owner's intentions. And understanding how a business is such a big part of an individual. If you own a business, a lot of your energy and investments and time is in the business. So coming to the decision of either closing the business, or selling the business, or doing something in terms of a drastic decision around the business is never easy, but more so, the owner's intentions have to really be taken into consideration. What does the owner wants to really do? Do they want to close the business? Do they want to just shut it down, or do they want to restructure the business in a way that it can be a going concern and can continue operating? Those are two very different intentions that will obviously result in different processes to be followed if that's what we really want to do. At the same time, one of the considerations is whether the owner decides to sell, to shut down the business, or to restructure. Does the owner has a plan B? And why is that important? Again, because if for some reason we go through a business insolvency and there is some directors' liabilities, or there are some other debts this individual or individuals would be responsible for, is what is their plan B? So I think it's very critical to have these discussions, and those are some of the points, in my opinion, are the most important to consider before deciding on what kind of insolvency a business should go through. Now let's move to how a business, a proposal to creditors works for a business. And you must have heard, and I think right now there's a lot of discussions around bankruptcy. Just to kind of step back a little bit, bankruptcy is also one of the options under the Bankruptcy and Insolvency Act. Bankruptcy is a legal declaration in which a business, an individual declared its inability to pay to the creditors. It applies to unsecured creditors, and just because the distinction with secured creditors, there would always be a guarantee for that. But also, the alternative to filing for bankruptcy is making a proposal. And a proposal for an individual works in a very different way, similar in terms of the agreement, but in different terms. For a business, the considerations are greater, because we have to really look into how a proposal for a particular business is really going to be beneficial. And the intention in the long term for having a proposal is that the business will continue operating, and that is obviously the best way to go, or the best way to restructure, so that the business can be viable going forward. So the proposal is an agreement that is presented to the unsecured creditors, to the secured creditors, to all the creditors in the company, to try to make a deal to repay a portion of what is owed. And this agreement is a legal agreement and is placed by the court. It has to be mutually beneficial. That's one of the considerations. Meaning the creditors have they have to be on board, number one, but they also have to see the benefit for them to approve the agreement that is being presented. For the most part, when it comes to what percentage is really involved, what percentage will be forgiven, it depends on different factors. I mean, the type of business we're discussing, the ability for the business to repay and to commit to a new plan. So I think from repaying as little as 10%, but it could also be 50%, or it could be more, depending again on the type of business we're discussing. And as I mentioned, it applies to all different types of debts, including suppliers, employees for termination pay. We're looking at judgment creditors, and the Canada Revenue Agency, which is one of the very critical, and for the most part, one of the more prominent creditors businesses have issues with. And certain debts will have to be repaid in full. And I mean, to those we may refer to some of the secured creditors, depending on the ability to repay them. But this, in particular, this portion is referring to the source deductions. When there is a debt to the Canada Revenue Agency for source deductions, which is considered a super priority, has to be paid in full in a proposal. And this proposal allows, normally, or the current terms allows for the source deductions to be paid within 6 months of the approval of the proposal. Now, I have situations in which the source deductions is such a high amount that is impossible to repay within the period of 6 months, and therefore different discussions around that will have to be done with the CRA for them to allow a provision to repay that in a longer period of time, which it has happened also again. But that what it means though is the source deductions will take a priority over any unsecured creditors or any other agreements that are in the proposal, and therefore, until the source deductions are paid, the rest of the creditors will not get anything out of the proposal. One of the benefits of having a proposal is the stay of proceedings. And the stay of proceedings is the protection the company will have during, from the moment the proposal is filed until during the process. What it means is that there's no, whatever legal actions are active have to be stopped, but then it will also deter creditors from starting or commencing in the new legal actions. One of the benefits, another one of the benefits is the owner never loses control of the business. The trustee is there to monitor the business at least until the approval of the proposal by the court. But then once the proposal is in place, once the proposal has been approved, the business owner remains under control, and it's just to complete the agreement that has been made. And one thing about also about proposals is that proposals can only be made using a licensed insolvency trustee. So licensed insolvency trustee, which is who I am, and the people in my industry, we are regulated by the superintendent of bankruptcy, and we have the ability to follow with the process of insolvency, being consumer proposals, bankruptcies, receiverships. So this is to confirm that only trustees can go through with the legal process of insolvency. So I think having an understanding of these descriptions around a proposal, I can share a story of a process that I went through for the last year. It was a proposal for a business that it was a staffing company. They owed, the debts were about 6 million. 2.5 of that was source deduction. And that was the sticky point of the discussion, simply because, again, the company was not in a position to pay that within 6 months as required by the Act or the current terms. So the CRA was really struggling to agree to that, and I can see the efforts for them to try to approve that. However, it went to all the way to the headquarters before it could be approved. So 1 year later of discussions, they finally approved it. The benefit of that is in this particular insolvency, not only save the tax dollars, because now they're gonna recoup the 2.5 million that was outstanding, but also save the business, which provide employment for over 700 people. So I think that was a great success story in terms of how a proposal really can be a lifesaver for some businesses. Now, you may ask yourself, do my debts need to be that high in order for me to make a proposal for my small business or personally? And they don't. Every situation is very different. Every situation is very particular. I think what is important to know is in a business is that the intention of the business is to remain active and to continue operating. That's very important. And is the business viable enough to continue making money? So if that is kind of the consideration, then yes, there's a very good opportunity for taking advantage of the proposal to move forward. In the personal level, I guess one of the biggest considerations is that if an individual has an asset or asset to protect, or there's a real value for the individual to make a proposal, then that is also an option. I always like to use this slide just to show that CRA, which is probably one of the toughest creditors to deal with, but I also think that they have been able to understand what businesses are going through for the last 12 months. So better discussions have been had in terms of dealing with businesses and how they can better support them. However, the CRA, as a very particular type of credit, have some collection remedies that are only given to them. No other creditor has that. And you're probably familiar with that. So you're familiar with how they can garnish bank accounts, they can register liens on real estate, on a particular piece of property, or they can also garnish accounts receivables. That's what they issue requirements to pay, which allow CRA to go to third parties owing money to a business and just ask and request them to send the money directly to CRA. The last part of the Income Tax Act, Section 160, is in my opinion, one of the most interesting and probably challenging remedies they have, because for those of you who are not familiar with this particular section, it allows the Canada Revenue Agency to assess third parties that had enriched from a particular asset that would have otherwise gone to CRA. For example, an individual has a property and he owes X amount, or he ought to know that he owes X amount of money to CRA, and he decides to either sell or transfer the property to somebody else. So CRA has the ability to go to this third party, and demand either the value of the property or the sale of the property. So Section 160 allows for that type of assessment, which is really broad in terms of how it could be applied, and so there are some certain conditions for it to be really in place. However, I've seen cases in which, for example, in a proposal that I dealt with a few years ago, an individual has paid for his son's university, and CRA, when it came the time to discuss the proposal, CRA was suggesting that they could go after the son for the money that he received from the father. Okay, this is to say that obviously it's a very broad section, and we all have to pay a lot of attention to it. But the reality also is, but dealing with CRA, there's just so much they can do. It's a lot of limitations. On the regular basis of collections, they only can allow for so much of length for people to really repay their debt. So unfortunately, for so many people, insolvency only becomes the only way to negotiate different terms, and more so terms that go beyond the periods that CRA can allow for. One important point here about dealing with CRA is normally collections, like any other type of collections, are I mean, their role is really to collect, and they can be certainly aggressive and pushy and all that. However, once there's a bankruptcy or a proposal, the files are transferred to the insolvency unit, and these folks at the insolvency unit are more seasoned, and they have a little more understanding of personal situations and business situations, and I think it allows for a different conversation altogether. And now to the last part of this short presentation is what remedies are available to creditors. And again, as creditors, is what is important to know is that if you have lent money to somebody, if you have sold merchandise to a company, or if you have provided a service to a company or an individual, then you are a creditor. And so what options are available for creditors? There's a couple of options. One of them is you can request an involuntary bankruptcy, meaning the creditor, you as a creditor can go to court and request for an individual to be placed into bankruptcy, which has to be, it's only in place once the court issues the order. And I think that it really allows for a process to be, in place so that you as a creditor get paid. And the second option is the appointment of a receiver. More so, a private receiver, meaning a private receiver applies when a creditor has a security over an asset or a group of assets of a business, and as such, you will have the ability to appoint a receiver and ask the receiver to sell those assets on your behalf and pay it. So these are couple of little points that I'm giving you here for you to think about. But right now we are a little short on time, so I'm going to pass it to you guys if you have any questions. Here is my information, my contact information. If you want to send me a particular question, please feel free to do so. In the meantime, let me know if you have any questions right now that you would like to discuss. I'm here for that.
Hi, Francisco. I just wanted to come on and say thanks for presenting. It's always great to have you at our events.
No
If
problem.
anyone has any questions, feel free to put them in chat. But I just had kind of a sort of a key question, I guess. What do you think is sort of the key takeaway that someone should get from your presentation, or like maybe the top 3 things or something like that?
Well, that's a great point. I think one of them is, number one, to know that there are options available for businesses.
Mm-hmm.
So we all know small businesses are struggling right now, and I think aside from the current financial aid from the government, which is great, some businesses already were struggling before that. So this is probably a great time to really look into how we can better restructure a business that is more viable going forward. So knowing that there are options, that I think is a good opportunity.
Yeah, definitely. I think a lot of people don't realize that there is, the options available to them, or that maybe they don't think there is, so they don't really look for them, right? So
Correct.
that's definitely a great point. Well, I don't see any questions in chat, unfortunately, so I just want to say thanks again for speaking. It's always great to have you at our events. Francisco has spoken at a number of events, so he definitely knows his stuff. It's always great to have. I know you mentioned your contact info. Do you maybe just want to pop it in chat there, just in case anyone wants to write it down?
For sure, I'll do that.
Thanks. And just to let everyone else know, so this is our final round of sessions for today, and then we have our panel starting at 3:30. So that's in about 11 or so minutes. Okay, great. Awesome. Well, thanks again, Francisco. It's always great to have you.
Likewise, you take care, okay? Thanks a lot.
Bye.